For pronouncement of judgment, item 15, supplementary list.
Yeah, it has been dismissed.
For pronouncement of judgment, production list, item 1.
We have read down the rules so as to save its constitutionality. You have to treat them at par. Otherwise, it will be violative of principle of equality enshrined under the Constitution.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 14.
May I please your lordship? Lordship, I beg to mention item number 6. Item number 6 will argue by senior advocate PJ Saikya, sir. He is not well today.
You have informed the other side?
Yes, your lordship.
Adjourn.
Yes.
Yes.
Highly obliged.
Very please, lordship. If I beg to mention item number 10, lordship. It's also connected with 9, lordship. Right? And I will take
Item number 10.
10, lordship. And also my senior is out of station, lordship. Today,
It is
lordship.
connected with 9.
9, lordship. I have taken consent from the item number 9, lordship, the government, lordship. It's it will be filed by the government also, lordship. So I have taken consent from
You
the
are
government.
appearing for?
I am here for item number 9, your lordship, Noor Shahid. My senior will be here for this matter, your
You
lordship.
have informed the government advocate.
I have taken consent and I also informed to the private owner also, lordship, yesterday, lordship.
We have not got any information, your lordship, and we haven't given any.
Do you have any objection?
Yes, your lordship.
Gentlemen?
Yes, your lordship. My senior is going to do the matter, your lordship.
That will be this, lordship. I'll do it.
Let the number come.
Oblige, your lordship.
May please, your lordship. I beg for listing of a writ appeal for 12th of August, your lordship.
It's the urgency in 12th of August. What specific date? Why?
Your lordship,
Why specific date 12th of August?
because in this matter, outstation senior advocate is engaged here.
12th.
Highly obliged.
Daily list for orders, item 1.
But the boundary wall construction is complete. It has been done.
It is completed.
Yes, I have a report.
I have given photographs.
31/7/2024. Construction is almost complete. But by this time, white person, all this thing, everything has been done.
I think confirm.
Yeah, what's your information?
Only thing, my lord, if in future complication arises, liberty may, lordship may.
Future, how you can anticipate once boundary wall is
Only-
there, road is already constructed.
That's true, my lord. Since we have fought so much to get into this, my lord,
But,
and considerable amount of time.
Road and the boundary, that was the problem, Lord. Ultimately, both have been done. As it is completed.
This is Suomo to PIL.
Yes, my lord.
Show to PIL.
No, no, not
Petitioner is Rajiv
PI
Kolita.
PIL
Rajiv Kolita.
only PIL. So not so much.
PL 7 of 15, Rajiv Kolita.
Initially, it started with the eviction of those unauthorized occupants in the High Court campus. Then boiled down to this issue.
Is there in other file? Okay. PIL petition.
PIL 7 oblique.
So that's right, but I
2015.
think this copy of the PIL is not available.
It has to be there. Hmm.
He pleaded, he thought, yeah. I know. Hmm.
Not to- Yes, আমাদের বিবেচনা অনেকটা
This PIL petition is essentially filed by the petitioner seeking a direction for the respondent number 3, 4, 5, and 6 to take immediate effective steps to evict the encroachers from the land of the Guwahati High Court situated in Mali Bagan, Hargoli, in bracket Guwahati, so as to facilitate construction of the proposed boundary wall and the staff quarters in bracket multi-storied building for stenographer and grade 3 and grade 4 staff of the High Court. Stop. During the pendency of the writ petition pursuant to the direction given by this court, the encroachers from the aforementioned land has already been evicted and the staff quarters have also been constructed. However, from long time, the boundary wall could not be constructed due to some obstruction raised by the individuals, and the road has also not been and road connecting to the land has also not been constructed. Would stop pursuant to the direction given by this court, particularly in the year 2024, the road has also been constructed, and today Mr. Nath has submitted a factual report wherein it is mentioned that the boundary wall of the land in question has also been constructed. Full stop. Lanet, counsel for the petitioner has frankly admitted that substantial compliance of the directions given by this court has already been made by the respondents. In such circumstances, when the purpose of filing the PIL petition is specified, hence no further order is required to be passed. The PIL is disposed of.
Liberty in future for any
It is
company.
always, we have not
That would
curtailed any
be, that would
liberty.
be a
Even when it pays any
fresh,
policy.
fresh cause of action, Malad, if it happens.
Fine. Much obliged.
Supplementary list for admission, item 16.
Meet resolutions.
Malad, in a particular tender process, the authorities require that if a person is blacklisted ever, he is disqualified. Now, I must fairly submit that there was also a requirement in the tender documents that if you're aggrieved by any clause within a particular time period, you must respond by a representation, whatever, in the official website. We did not adhere to that condition. We did not submit any online representation within the time frame in the portal. But that may be fatal in a case. We did not do so. However, I must say that we submitted offline applications before the tenders was even last date for finalization. Now, when we approach this honorable court, that the tender condition is on the face of it not sustainable in law. Because due to currency or operational period of blacklisting, of course, I may be debarred. But once my debarment period is over, there is no embargo in law that I cannot participate. That was my case. Now, the respondents, rightly so, pointed out that I did not adhere to submission of that online representation within time, and that would be fatal. To the counter, I submitted, my client actually, of course, that had it been the case of the respondents, that if I would have submitted, they would have favorably considered and accepted that yes, blacklisting forever.
Question of consideration only arise when you apply for online. If you have not applied, there is no question of any consideration.
Correct, Madam. But they went one step further. In paragraph 9 of the affidavit they had filed, they cleared up their mind, stating that we stand by the clause because we do not want a person of doubtful integrity. Therefore, the clause, they stood by the clause. So regardless of my submission is there for consideration. Now, the end result of the consideration is what is on record. They've submitted that on record. So what my prayer before your lordship is that I am not praying for being awarded with something or any technical consideration which we do not have the judicial expertise or otherwise for that. All what I'm praying is that the clause that once blacklisted, debarred forever is so harsh. Kindly allow me to participate and no more. That much.
Can it be once the condition is there that a person ever blacklisted is not supposed to participate in that? How can we ignore that, sir?
My lordship,
And
that was my submission.
regarding that clause is harsh or whatever it may be, ultimately it's the discretion of the state. It can very well
My lord,
impose the conditions and this.
so far as very rightly following, my lord, my stand was 2012 I was blacklisted, 3 years, 15 gone. After that, I'm also into contact with the IIT. Now, during the operational period of a person, if it's blacklisted, my lord, the normal understanding would be the period of blacklisting.
That is their prerogative. If they find that any person who was ever blacklisted is not a suitable person to execute a work, that they are well within their rights to and these conditions. How can we sit as appellate authority over such conditions, sir?
But so all respect, my lord.
That is
This,
their prerogative.
otherwise also, I have to bow down to your lordship, my lord. But the condition, otherwise, then
It is not like this, that this condition is only applicable to you, any person, any contractor ever blacklisted. It is
Well, I am on the
applicable to,
genesis of the condition.
everyone.
I'm on a genesis. It is in conflict with the law of blacklisting. The law of blacklisting would demand that once blacklisted for a reason or debarred for a reason, there will be it would end in a point of time. It is not forever, my lord. But if this condition is given effect to after judicial scrutiny, then any person ever blacklisted is gone. It strikes to his right to livelihood, my lord. If I'm ever blacklisted in life, I'm gone.
Acha, Mr. Banik,
My lord,
see, there is a clause in the tender,
My-
23.8.
my lord,
They have acted as per the clause,
my lord.
correct? Have you challenged that clause?
Yes,
Okay. Now, terms of the tender, Tata Cellular is
My-
well settled.
my lord.
In your order of blacklisting, you must have challenged that order. No, you didn't.
Order of blacklisting,
The earlier order, 2004 order,
2012 order.
12 order.
12 order is gone.
No. Did you challenge that order of
It
blacklisting?
became infraction by the course of the day. We had filed petitions earlier,
Ah.
but they also in some, the IIT Guwahati at that point of time, they chose to go ahead with other tenders and all. So therefore, that those is not, I do not have the copy of these orders presently, my lord, of course.
So in this,
And I'm also in business with the IIT.
listen,
I've
listen,
done,
in this case, the only relief that can be considered,
my lord,
but not today at some stage,
lordship.
is what should be the prospective effect of the blacklisting. But
Yes,
you can't get into the contract process because of the clause 23.8.
in the
You
writ
make your
petition, my lord,
submission, we'll pass the order.
lordship, in the writ petition, my lord, since I challenged the validity and correctness of 23.8 on the touchstone that it is in conflict with the law of blacklisting. And I being once blacklisted, if this is allowed to hold good, then I'm gone forever.
Consider your argument, but till we take a decision on this, whether it is harsh or whatever,
My
it may be, what you are saying, we accept it. Until and unless we can't allow you to participate in the tender process.
The order of civil judge against.
In that
That
case,
we
my lord, since I've submitted by tender,
Consider your.
then it would become infractious because so far as I'm concerned in the,
Infractures or whatever it may be, until and unless we interpret this clause 23.8 and comes to the conclusion that it has no, on the prospectively, it will not be applicable after the period, blacklisting period is over. We can't allow you to participate in the tender process. Suppose tomorrow we.
I
decide
get the
against
point,
you,
note this,
then
I get the point. In these circumstances, my lord, may I proceed only it's the argument of the law point and no more. Could it be on a very short date, my lord? Just on the law point. And we are not on facts anymore. Tomorrow, Monday, Tuesday, any day, my lord.
Yes, Mr. Secretary.
Lordship, so far as this tender is concerned, Lordship, his doors are closed. But that academic discussion may definitely take place.
File your counter vote.
Yes, Lordship will file. Lordship will kindly give us 2 weeks time.
Notice. Look at, Mr. D. Secretary, Advocate General, accept notice on behalf of all the respondents.
Lordship.
Service is therefore complete. Having heard the, इसको ऐसे लिखना. Having heard the learned counsel for the petitioner. Appellant. And we are of the view that matter requires consideration, hence admit. Notice. Learned Advocate General Mr. D. Sekia accept notice on behalf of all the respondents. Counter to the writ appeal be filed by the next date of hearing. Put up this case for final hearing in the month of September 2024. Assistant. D. Sekia.
He accepts notice. Not advocate. Your name, please, ma'am?
He does accept notice on behalf of all the.
Deeply obliged.
For hearing, daily list item 2.
May it please allow. On the last occasion, Lordships indicated that we should file our written argument, which we have done. Now, in this case, in the ultimate analysis, my lord, everything depends upon interpretation to be given to that particular appendix. The fact that we were upgraded and that upgradation is not under challenge. Now, what would be the consequence? Now, other side would like to contend that promotion and upgradation is different. That is absolutely correct. There is no doubt about it. Because, my lord, in service jurisprudence, we find on the facts of each case, different propositions have been laid down by the Supreme Court. Now, I'll rely upon a judgment of the Supreme Court of Delhi Judiciary, my lord, where following upgradation, similar argument was advanced. Supreme Court did not accept. Because, my lord, equity knows no halfways. If I attain the stage of, assistant engineer, maybe by virtue of upgradation, maybe by virtue of promotion from their diploma engineer, I lose but my earlier efficacy goes. So my status would be that of an assistant engineer. If I'm an assistant engineer,
You mean to say that Delhi, the Supreme Court in the Delhi judicial case
yes,
has said that this upgradation amount.
yes, yes, my lord, yes. My lord, in that compilation, we have given the judgment. If your lordship would kindly have that. This SN Dhingra versus Union of India. I think the yellow flag is the compilation.
Yes.
If your lordship would kindly come to page number 127 for the facts.
Yes.
At page 127. My lord, in the written argument compilation, we have annexed the judgments on.
It's me.
Yellow, no?
Yeah.
If your lordship would. Oh, thank you. At page 127.
Yes.
This petition under Article 32 by direct recruit to Delhi Higher Judicial Service assails the inclusion of respondent number 5 to 8 in the gradation list drawn up by the High Court of Delhi by an order dated 22/8/2000 pursuant to direction given by this court in writ petition number so and so. These respondents have been continuously working in Delhi Higher Judicial Service with effect from 18/1/86, but had been posted as Chief Metropolitan Magistrate on account of government decision of upgradation of the said post of Chief Metropolitan Magistrate. The petitioners, on the other hand, are directly recruited officers to Delhi Higher Judicial Service in the year 88, pursuant to a selection made in accordance with the recruitment rules. The bone of contention, the bone of the petitioners is the contention of the petitioner is that respondents who are continuing as Chief Metropolitan Magistrate must be held to be junior to the petitioners inasmuch as their decision was subject to challenge in appeal before the petitioners who were appointed as additional district and session judge, and the High Court committed error in including the name of these respondents in the gradation list pursuant to the direction given by this court in constitution bench decision by not properly understanding the directions in question. So, my lord, this was the factual background. Now, if the lordship
Mr.
would kindly-
Chaudhary, just interrupting you for a moment. We have got a feel of what your case is,
Yes,
but we would like to examine this contentious issue from a particular perspective. Because as you have said, these judgments are all rendered on the facts of their case. And that is always the case.
yes,
Now, please address us on one point.
Yes.
If you want to contend that usually promotion is given to the individual and upgradation happens to the post.
no, my
Right.
lord, sometimes what happens, upgradation happens not only to the person, also to the post.
Coming to the point,
Ah,
we are putting it to you that promotion is a phenomena which normally takes place in respect of a employee, a member of the service. Upgradation pertains to the post. So a post can be upgraded from one pay scale to a higher pay scale. That's permissible. But if you are contending that by upgrading the post which your client was holding, he also stood to be upgraded to a higher level. To succeed in that argument, you would perhaps have to satisfy us on one count that this process of upgradation, which takes your client to the higher level,
Has some legal backing.
is in consonance with the rules pertaining to promotion and
Absolutely.
seniority.
Absolutely, that is our case.
So,
Please come to the, if that be so, my lord, even before even I place the judgment, please come to the regulation.
and to that extent,
Yes,
it meets the requirement of Article 16, in the
yeah, 14 and 16.
14
Yes,
and 16
yes,
of the
yes,
Constitution,
yes.
which
My
is
lord,
that
will kindly have the regulation, my lord. I think the copy is before lordship. Now, please come to regulation 4.
2012 regulations.
Yes, my lord.
Yes. Yes.
Please come to regulation 4, sub-regulation Roman 3, my lord. At page 3 of the book compilation.
Yes.
Now, one speaks about the services which comprise in the cadre. 3. Board may by resolution may upgrade or downgrade within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government. So, my lord, statutorily power has been given to the board by a resolution to upgrade or downgrade within the sanctioned strength. Now, why this happened, my lord? There was a direction by the central board. The genesis, I must place it. If your lordship will kindly come to page number no, page 247, my lord,
page
of the
247
memo of appeal. 251 is the operative. My lord, the result minutes of the 75th board meeting held on 19th of June 2001. At page 247 it starts and the operative portion is at page 251. At page 251, the heading upgradation of the post of the junior engineer to assistant engineer as per Central Pollution Control Board norm. The members have secretary apprised the board that as per Central Pollution Control Board, no diploma engineers should be recruited and existing diploma engineers should be upgraded from the post of junior engineer to assistant engineer, aiming at increasing the efficiency of the engineering service of the board in future. Central Pollution Control Board also desired the state boards to follow the said policy. The matter was discussed. The board agreed to the policy in principle, but considering the present financial position of the board, it is resolved to upgrade those posts of junior engineer which have confirmed eligibility of norms phase-wise. Board will not fill the present vacant post of assistant engineer till it is decided by the board otherwise. Member secretary of the board will submit service sheets of the upgraded engineers person-wise, specifically mentioning the period of qualifying service, the scale of pay, the basic pay, departmental proceeding, if any, of the junior engineer for final approval of the board. So, my lord, this was a decision taken pursuant to the direction of the central board in administrative exigence. It was not a case, my lord, where any personal favor was shown to somebody.
No, Mr. Chaudhary, that is correct.
Hmm.
But according to us, that will have no bearing in your case. The reason is as follows. Let us put a small and simple example. Let's take the case of judiciary, district judiciary. There are grade 1 posts, grade 2 posts. So supposing 3 grade 2 posts are upgraded to grade 1, will it mean that the person's
Incumbent will also. go.
incumbent also become grade 1 officer? That's the question here.
No, my lord, no, the example which your lordship has given is correct. But in the facts of the present case, what does the settle board say? They henceforth, you don't recruit diploma engineer. And the decision taken was until this upgradation process is complete,
Hmm.
this direct recruitment to assistant engineer is stopped.
Correct, but is there any decision that the incumbents holding the post of junior engineer
Yes,
would
now yes,
also
yes,
automatically stand?
yes, now please come to 147. That's the decision now. That was the decision in principle, and the order is at page 147. 147. Under section 22A of the Water Prevention Control of Pollution Assam, so and so, the following 14 junior engineers of this board, having experience of more than 10 years of service, are upgraded to the post of assistant engineer with immediate effect.
And this order is not under challenge.
No challenge. It's attained finality in 2005. Had it been
And they, after this, the post of junior engineers were abolished.
Yeah, it is not being recruited any further. Thereafter, it has not been done. Now, it so happened, my lord, as a junior engineer, we could have earned promotion also as assistant engineer. But because of exigencies of service, before we could earn the promotion, in which case we get the benefit of the appendix. Before we could earn the promotion, this decision was taken. So where is our fault? Why should we be penalized for that? And my lord, this writ petitioner, whose instance the judgment has been delivered, he was born in the cadre in 2012, whereas we were born in the cadre in 2005. And at his instance, my lord, our everything has been, set at naught. So we have been upgraded to the post. Now the question is, now only small point which according to me, subject to what your lordship may say, my lord, if your lordship kindly comes to this compilation rules, regulation, lordship kindly comes to page number, there is of course provision of relaxation also, page number 33. Appendix 2.
Yes.
Now kindly see, my lord, serial number 5, assistant executive engineer. Then please come to the column number 9 remark. Exists for existing promotee engineer, the qualification shall be relaxed to diploma in engineering. If we would have earned the promotion, in which case diploma would have been good enough for us. Now we are upgraded. So whether we should be treated at par or not. Otherwise, my lord, we have no case. This is the case, my lord. End of the day, when we were upgraded in the administrative exigency way back in 2005, and nobody has challenged that, and it has attained finality, at this stage to say that we do not have the required qualification, the only case is we do not have BA. Sorry, BE or BTech. That's the only case. Yes, we admit, but we have to be constituted as a promotee.
So that is why the question was, Mr. Chaudhary, that your upgradation has to be in consonance with the rules.
Yes, and rule 4.3, regulation 4.3 permits.
Where is it?
Yes, same compilation. Page number 3. Four three. The board may by resolution may upgrade or downgrade post within the sanctioned strength. However, in addition to the existing strength of the cadre, shall be with the approval of the government of Assam.
So your clients could have earned a promotion as per
Otherwise
the-
also,
but they don't have the qualification.
no, as a diploma holder, we could have earned a promotion.
Promotion
we-
to-
Promotion from diploma engineer to assistant engineer.
No, but you
That's-
said they didn't.
No, my lord. Normally, supposing this central board, normally, supposing this central board direction would not have come, then at one point of time, who would have become assistant engineer by earning that promotion. So that's a rule prevails in every department. There is a certain percentage for promotion. Now, their only case is, my lord, if your lordship will kindly come to rule 9 at page 9. This is their only case. Rule 9 2A at page 9. Qualification, experience, and promotion of employees under engineering and technical service. For recruitment to the cadre of assistant engineer in the board, the required qualification would be bachelor's degree in engineering, that is BE, BTech or BSc in engineering, etc., etc., etc. The educational qualification and experience for other posts under this service shall be as per table 2 in appendix 2.
So that is the question, Mr. Chaudhary.
Yes,
9(2) sub-rule A says to be promoted or to be holding a post of assistant engineer,
yes.
the incumbent has to be B.
B, we are not.
You are not.
Ah.
So how would you have got promoted to assistant engineer?
No, my
under the
lord, there
rules?
is a quota for promotion from diploma engineer to assistant engineer. That's why in the appendix 2 says that for promotees, the diploma will continue. Page 33. Page 33, my lord. Page 33, appendix 2. Column number 9, that's remark. For existing promotee engineers, the qualification shall be relaxed to diploma in engineering. Our case is, my lord, we should be treated at par with the diploma engineers, diploma holders, who would have otherwise would have been a promotee. That means if I am promoted from diploma in junior engineer to assistant engineer, there's a certain percentage, then by diploma is good enough, which rule also says. So we say, my lord, that this upgradation has to be construed or treated at par with the as a promotion. That too in the exigencies of the administration and rule regulation 4(3) permitting such upgradation.
And lead petitioner holds a B degree.
Yes, that's
Well-
their only case.
He was directly recruited.
Direct recruited in 2012.
So he wants seniority over.
Us. No, he had challenged everything. Because in the meantime, my lord, we have been promoted as assistant executive engineer.
The challenge is to that.
Their case is, but if your lordship would kindly come to the writ petition, 2-3 paragraphs will make the position clear. Petition document page rakhile. Page 37. If your lordship will kindly come to page 59, my lord, of the paper book.
Just a minute.
Yes. Para 20, para 20, page 50. Oh. Yeah, diploma engineer level promotion cycle, engineer, provision promotion side. And he provision promoting engineer. Diploma engineers Chairman of power person.
Mr. Executive.
So to keep 52 of this regulation.
Promoting English, which are upgraded. No, no, and you are not having this certificate. These relaxation it doesn't apply to you, then you don't have to apply. It's we. Promoting.
No, no, it is an but it is information knowledge there. Engineer level of the promotion category. We don't do provision to there for promoting diploma will be relaxed.
But he's in the. ये तो कभी
For the purpose of this promotion on the post of assistant engineer,
Assistant executive engineer.
assistant engineer,
Yes,
what is the qualification?
diploma, Miller. For promotion, diploma holder can otherwise direct
Junior
recruitment
engineer, on the basis of his qualification diploma, he can be promoted
And-
to
and
the post of
experience.
assistant engineer.
Yes,
And for the purpose of this promotion on the post of assistant executive engineer, B is required.
same.
be easy.
Don't same.
No, even, no, my lord, under the regulation of 2012,
Yeah.
even to become, even for direct recruitment, it is required. For promoting, it is relaxed.
It is relaxed.
For promoting, it is relaxed.
No, it is- they will do it same. Right. इसमें 5 years यहाँ जाएगा. In 2 years. Not open. तो फिर आपको नहीं मिलेगा. You are not entitled. तो आपका सारे Mr. Chaudhary, how the learned single judge has dealt with this
Yes.
argument?
Yes, yes. Want the page schema? My lord will kindly come to page 274.
These are the points.
Or rather, lordship will kindly come to page 283.
This internal pay.
Internal page, my lord, 31. Yes.
Yes.
After quoting the provisions, para 32. The third question for consideration is as to whether the impugn orders dated 8/10/20 and 9/10/20, whereby respondents 7, 8, 9, 10, and 11 were promoted to the post of assistant executive engineer, and also as to whether the impugn order whereby respondents 17 to 21 were upgraded to the post of assistant executive engineer was required to be interfered with. The promotion of respondent number 7, 8, 9, 10, and 11 and upgradation of respondents number so and so would not have been made in their favor on the ground that they did not have the requisite qualification of BE, BTech, AMI, etc. In terms of regulation 9(2)A and remark column as column 9 of the table number 2 in appendix 2 also do not provide any relaxation in favor of the said respondents. Further, with respect to respondents number 13, 14, 15, 16, and 17, it is not known on what basis Respondent Pollution Control Board had upgraded the officers by the impugn order dated 9/10/2020, which was dehorsed the provisions of regulation 7A1, which mandates recruitment to various posts can be made by way of a direct recruitment or by promotion or by deputation or on compassionate ground or by way of a contract. Regulation 4.3 only empowers board for the purpose of upgrading or downgrading posts within the sanctioned strength. However, with the approval of the government, there can be any addition to the existing strength to the cadre. However, power under regulation 4.3 of the regulation does not empower board to upgrade or downgrade the service of an officer from the post of assistant engineer to the post of assistant executive engineer, as that would be in violation of regulation 7. For the reasons above mentioned, this court is of the opinion that promotional orders dated so and so of respondents number 7, 8, 9, 10, and 11 and upgradation of respondents 13, 14, 15, 16, and 17 are in violation to the regulation of 20, as they do not have the requisite qualification for which the said orders are liable to be interfered with. The only reason is, my lord, we do not have BA, BTech BA.
So their argument will have legs to stand if one takes into account the contention that the respondents, that is the appellants here, their integration into the or upgradation into the cadre of assistant engineer
Was bad.
was bad. But that is not under
That is
challenge.
not the case.
So one has to presume that they were born into the cadre of assistant engineer
In
without any
2005,
default.
before he was born.
So after that, next stage is promotion.
Yes.
And that the promoter engineers, the rules permit,
Yes.
even the diploma engineer.
Once I'm an assistant engineer, and in case of diploma holders, it will be, sorry, in case of promotees, it will be relaxed. Now I'm upgraded. Question is, my lord,
It's a very
something has
short
to-
point, actually.
That's
It's,
the only point.
It's been.
In my humble submission, appendix 2, column 9. My lord, end of the day, we notice in some Supreme Court judgment, in view of peculiar facts of case, different views have been taken. My lord, there is no quarrel with the proposition that perhaps upgradation is not a mode of recruitment in terms of the regulation. I cannot dispute that. But question is, here is a case. Had it been a case we aspired, based on our application, something is done, then I can have. Now, it was done in administrative exigency. That's why sometimes, my lord, it is said when action is in public interest, then the benefit must percolate.
And that action has not been called into question by
Nobody
anyone.
has called in question. And way back in 2005. Now, can we contemplate a situation in 2005, I am being upgraded as an assistant engineer and I cannot earn promotion in my lifetime because I do not have B degree. I think that will be too harsh, my lord. And moreover, my lord, if your lordship will kindly come to regulation 52, it saves all this action, my lord. Please come to repealing and savings at page 31. Please come to 52B and 49 is the power of relaxation. Notwithstanding the provisions of regulation 51, all orders made, actions taken under any rule, regulation or resolution of the board prior to the commencement of this regulation in respect of matters relating to condition of service of the employees of the board shall be deemed to have been validly made or taken under the corresponding provisions of this regulation and shall be treated as valid. So all the actions have also been validated, my lord.
And the 2005 action was under which rules?
That was, my lord, basically based on the, at that point of time, my lord, that air prevent. Between and to actually. If your lordship would kindly come to section 22 at page 7, my lord. Powers and duties of the chairman. Chairman shall have overall control over the functions and activities of the board. Chairman may undertake tours within India for carrying out the functions. Then please come to 3, my lord. Subject to rules, if any, made under subsection 3 of section 12, the chairman shall have full powers in matters of appointment, promotion, confirmation, transfer, disciplinary proceeding, and termination of service of officers and employees of the board. So since it was at the very formative stage, my lord,
No, where are the cadre? Where is the cadre strength of the service? Junior engineer, assistant engineer? Is it prescribed by these rules?
No.
at that point of time, I hate it here to nine. My lord, presently we know after the
So
regulation.
that's
has
right.
come-
See, Mr. Chaudhary, why we are asking is,
Yes.
let us get into the root of the matter. He will also argue. The point is, all these arguments are based on 2012 rules,
Yes.
that relaxation, etc. Fair enough. But in 2005, when your clients were upgraded, these rules were not even in force.
Yes.
Which rules were in force?
No, my lord, basically our upgradation was done based on that central board's directive.
So at that time, was there a rule which says they will have to be graduates to become B
No.
degree holder to become?
No, it was not there.
Then even that argument doesn't survive.
It was not there. It is only in 2012 regulation it has been.
Because subject to what Mr. Sinha may argue,
আসলে স্যার এটার মধ্যে করেছিল স্টেট
unless a case is made out that this, following the upgradation, the upheaval of the private respondents was made in a manner which is contrary to rules,
Then prevailing.
then it will be difficult, Mr.
There,
Sinha.
there must be, I think, some cadre.
Actually, my
Must
lord,
have been, must have been
These
defined.
boards were in the formative stage. So at that point of time, power, that's why it says subject to rules.
But-
So many state
just-
governments,
You just see rule 24, this,
24 of the act, my lord.
this rules, sir.
91.
I'm sorry, yes, 24, one second. Yes,
Recruitment of
recruitment,
staff.
yes.
Yeah,
Recruitment to all posts under the board shall be made direct recruitment, promotion, re-employment. The board shall ordinarily subject to such standards as laid down from time to time. Pay scale, etc. Employees shall be entitled to dearness allowances.
the
Employees of the
employees of
board.
the dearness allowance compulsory, house rent allowance,
Yes,
and
yes.
so other rates. applicable post carrying corresponding scales of pay.
Yes,
The employees of the board shall be governed by this for the purpose of reimbursement. Employee of the board shall be governed by the same rules in respect of scale of pay as prescribed by the state government for its employee in
Yes,
corresponding
yes.
status, unless otherwise specified the board for time of creation. So corresponding status, what is the corresponding status of the state government with the?
my lord, actually this litigation sprang up only when we were made, this subsequent promotion was given. They were keeping mum all proud, my lord, regarding our initial upgradation. So regulation came for the first time in 2012. Hello, how to? হয় না দাদা? আগতে তো নাছিল।
General. So, Mr. Chaudhary, let us.
Yes,
Mr. Sinha, you can argue whatever you want, but first answer one question. Straight answer we want. Your client was born in the cadre in the year 2012.
Yes,
All your arguments are based on 2012 rules.
right.
At that point of time, the appellants were all working as assistant engineers.
Right,
Correct.
correct.
Whether they were born in the cadre of assistant engineer rightly or wrongly, we will not look into that. That is not under challenge. And the 2012 rules were not even in force at that point of time. But 2012, when your client came in, they were assistant engineers. Their promotion to the next rank of assistant executive engineer follows the norms laid down in Appendix 2. And that says for the promotees, they can be diploma holder engineers. Where is there to, why should the code go into what has been upgraded, what has not been upgraded? They were assistant engineers. Your client joined as assistant engineers. They could have been promoted because it was permissible under the rules. They were senior to your clients. What is there to argue in this matter?
Yes, Your Lordship. Your Lordship, first of all, the methods of recruitment. I'll come, Your Lordship. The method of recruitment. First of all, regulation 2012 came in. So subsequent to the incorporation of that regulation, whatever happens will have to happen as per the regulations. There is no doubt about that. Now, as per the regulations, Your Lordship, although Your Lordship has gone through it, my respected senior has gone through it, I'll just.
So why don't you first tell us what is your formulation? We'll go into the details.
My first,
You get chance to argue, but what is the formulation?
my first formulation of law is that not having the required qualification to be considered for promotion, all these peoples, that is appellant number 1 to 5, have been promoted in violation of regulation 7,
Promoted to which post?
assistant executive engineer.
Why? Which qualification they did not have?
The qualification of graduate, B,
But
that is 9-2.
Appendix 2 says something else.
9-2, I'll come to that. But 9-2 says that you have to be a graduate. Page 8, Your Lordship. Subject to suitability as may be decided by the selection committee and by the appointing authority as set forth in regulation 10, and also subject to the possessing such qualification and experience prescribed under table 2 and to 7, appendix 2 to 8 of regulation 7-4, appointment by direct recruitment or promotion to the following categories of posts shall be made by appointing authority on the basis of select list prepared by the selection committee as referred to in regulation 14. We are concerned with serial number 5, assistant executive engineer. Now, the next page, your lordship, 9(2). Qualification, experiences and promotion of employees under engineering and technical services. Number A, for recruitment to the cadre of assistant engineer in the board, the required qualification will be bachelor degree in engineering, BE, BTech or BSc in engineering in chemical, civil, environmental or mechanical engineering. So admittedly, your lordship, the appellant numbers 1 to 5 did not possess the qualification of a graduate.
Read the next sentence.
Yes,
The educational qualification and experience for other posts under the service shall be as per table 2 in appendix 2,
See table
33. The appendix says, your lordship, the remarks column, the right hand side, page 33, your lordship.
Yes.
For assistant executive engineer, it shall be by 100% by way of promotion. So how could the appellant number 6 to 10 have been upgraded?
We will not go into that question.
that
Don't
was,
even
they
hurt-
they were upgraded way back in the year 2005.
No, your lordship, I'm sorry, I could not get the facts correct from my part. Appellant number 1 to 5 have been promoted to the cadre of assistant executive engineer. And appellant number 6 to 10 have been upgraded to the cadre of assistant executive engineer in 2020. That is under challenge, your lordship. I am not challenging something which happened in 2005. In 2005, all these appellants were upgraded to the cadre of assistant engineer. That is not under challenge. I was not born in the cadre. That's none of my business to challenge it. I have challenged only when my rights have been violated, your lordship.
So you are assailing the upgradation of those junior engineers who
No.
were then?
I am assailing the promotion of appellant number 1 to 5 to the cadre of assistant executive engineer and upgradation of appellant number 6 to 10 to the cadre of assistant executive engineer, which took place in 2020.
Acha, they are both in one appeal.
Yes, and that is also not maintainable.
There appears to be a misjoinder here.
Yes,
My lord,
that fact is not.
Two different groups of appellants.
Yes.
together.
no, no, they filed the same writ petition, same judgment, we are against that judgment. No, they filed the same writ petition in one writ petition.
Mr. Chaudhary.
Yes.
We see there is a little technical problem here. If you want, we'll continue and reserve our order.
Yes,
You see, all the arguments you made are pertaining to those 7 or 8 appellants who were upgraded in 2005.
all were upgraded in 2005.
But he's saying
No,
some,
I'll explain, my lord, what happened. We are all were upgraded in 2005. There is no dispute. What had happened, by 2 resolutions, 5 of them were promoted and 5 of them were upgraded as assistant executive engineer. Those orders were challenged before the learned single judge, which have been upheld. That's why I think for
Page 114, 1 and
why
1.
the heading happening. If your lordship would kindly come to
Page 114.
page, my lord, 141, my lord. Page 141. 102nd board meeting. Earlier one was, my lord, page number 147, 247 and 147. 247 was the decision of the board and order is at 147. Now please come to 141. And the operative portion is at page 142. Agenda item number 3. Proposal for upgradation of the following posts. We are concerned with, my lord, from assistant in C, from assistant engineer to the post of assistant executive engineer. Now please come to C towards the bottom. 10 years of minimum total service as assistant engineer in the board. After thorough deliberation, 13 number of assistant executive engineer may be upgraded to executive engineer. 2 number of assistant environmental scientist may be upgraded to executive environment scientist, and now we are concerned. And 5 number of assistant engineer may be upgraded to assistant executive engineer, keeping the cadre strength as 264 number as revised on 2013-14. This upgraded post will automatically come to the original cadre upon retirement, termination, resignation of the above mentioned post. The board member has agreed to upgrade this post under section 4.3, chapter 2 of the PCBA regulation. However, an intimation may be sent to the state government.
So how many appellants are beneficiary of this process?
5.
5.
Yes.
Now, the argument which you made for the other 7,
Yes.
that when they were upgraded, the writ petitioners was not even born in the cadre,
Yes.
will not apply in their case.
Yes.
No.
In their case, it will not apply.
No, my lord, I'm coming to that. What I'm saying is, my lord, all the appellants were upgraded as.
Mr. Chaudhary, please understand,
Yes.
whether the upgradation process was right or wrong,
Yeah.
that we are not going into in case of those.
Why assistant engineer?
But here we will go into it. Because this happened after the 2012
Yes.
rules came into force.
Yes.
So there is a clear conflict of interest. between-
My lord, now, Lordship will kindly bear with me now. I'll answer to that. Now, his challenge is very limited. He says, be it promotion, be it upgradation, you cannot do because we lack the basic educational qualification. Am I clear, my lord? If your Lordship will kindly come to page number 69, that's the writ petition pleadings. Let us be very clear about the things. Please come to page 69. This is the writ petition. Para 24, 25.
Mr. Chaudhary, the problem is you are not arguing the writ petition. The learned single judge has held that these 5, their upgradation was in violation of the rules. It's not only about education, qualification.
No, I'll deal with it, my lord. I'll deal with it. Please come to para 24. That the petitioner respectfully begs to state that regulation 9.1 governs the manner in which promotion has to be made to higher cadre, and accordingly appendix 2 provides that all posts of assistant executive engineer are to be filled up by promotion, that is 100%. It further stipulates that one has to have 5 years of service in the feather cadre of assistant engineer for being eligible to be considered for promotion. It categorically stipulates that one must possess the qualification of BE, BEd, etc., for being eligible for promotion. However, qualification shall be relaxed to diploma engineer in case the incumbents are or have been promoted in this state feather cadre, not otherwise. The petitioner respectfully begs to state that Pollution Control Board Assam regulation clearly states that the post of cadre of assistant executive engineer have to be filled up by a promotion from the cadre of assistant engineer, and incumbents who are diploma holders in feather cadre of assistant engineer can be considered for promotion, provided they were promoted to the cadre of the assistant engineer, meaning thereby scope of diploma holders for promotion to assistant engineer is subject to the condition that they were brought to the cadre of assistant engineer by way of promotion. Now regarding upgradation, that the petitioner respectfully begs to states that private respondents number 7 to 11, who were diploma holders, were initially appointed as junior engineer in Pollution Control Board. Thereafter, they were upgraded to the cadre of assistant engineer by order dated 30/12/2005, which clearly reflects the private respondents 7 to 11 have been upgraded in the cadre of assistant engineer and not promoted. And therefore, in view of the same, under no circumstance, private respondents number 7 to 11 would have been promoted to the cadre of assistant executive engineer. That the petitioner respectfully begs to state that in the similar manner, private respondents numbers 13 to 17 are all diploma holders and were initially appointed as junior engineers, and they were upgraded to the cadre of assistant engineer by order dated so and so. And as such, under no circumstance, private respondents 13 to 17 would have been upgraded to the cadre of assistant executive engineer. Further, as the regulation provides that the cadre of assistant executive engineer has to be filled up by promotion, hence there is no scope for upgradation. Now, my lord, they are applying the same yardstick to either be it promotee or be upgradation. Only distinction being, my lord, an additional argument was advanced in case of upgradation that after the regulation has come into being, upgradation is not a mode of recruitment. Let us be very clear about it, my lord. Now, my humble submission is, if you are prepared to concede my state, qua the upgraded appellants who have been subsequently promoted, what is the difference between the two? Because in that case, my lord, the same appendix 2, column 9 will be attracted. Once I am assistant engineer, by whatever method I may have come in, now my further promotion or upgradation is contemplated in the regulation. Their only ground is I don't have BS degree, sorry, BE degree. That is an obstacle which I have already overcome.
Mr. Chaudhary, just consider this, if necessary. Do you want to split the appeal between the two batches of appellants? If you say no, that will proceed accordingly. But we are seeing some difficulty here because according to us, the horizon is totally different for two sets. Those who were upgraded in 2005, those who were upgraded in 2020, they are according to us complete separate class. But you are free to press this composite appeal. In that case, we will answer it accordingly. But
In that case, Lordship will kindly let me also discuss the issue with the clients also. My lord.
you have understood the
I
point.
have understood.
See, if we go into the question whether upgradation can be equated with promotion under the rules, that will be applicable
No,
for
that it cannot be. As a proposition, it cannot be.
then
my
the
lord.
consequence.
Whether in the facts of a case it can be, that will be another issue. As a proposition, it can't be, my lord. That I'll never make that argument. Merely because I'm holding a brief for some upgraded.
You see, the problem is the learned single judges held all these upgradations and promotions were contrary to rules. So to reverse that, we have to record our findings.
Anyway, my lord, Lordship will give me some time, my lord. Definitely I'll come back to your Lordship, Monday or any day, my lord. I'm sure now they will allow the appeal for the network.
27th August.
Next day, but Lordship, pose the query regarding the cadre strength that I'll place on the next day. You have given it.
The Lordship, I filed my written argument also along with the judgment.
yeah,
The judgment relied by
You
me.
come up with the maintainability judgments. You have SL the maintainability of the writ appeal, right?
No, I've not
You have
assailed
not.
the maintainability. What I'm trying to say is.
According
yes,
to you, writ appeal is maintainable.
Your Lordship, that point I'll
You
argue.
seem to be very, very confused, Mr. Sinha. So
On
much
that
of
aspect,
confusion
on
is
that
not
aspect.
good. 10 minutes back, you said it is not maintainable. Now you are saying it is maintainable.
Item
We have
three.
given two books, let it be retained in the file, or we'll give it on the next date, my lord. देख से हेराई जाओ कर। Deeply obliged.
In item 3, matter, the forest department was to appraise this code about the action taken report so far regarding eviction of the encroachers from forest land.
Yeah.
The DFOs were to answer.
Yeah.
Lordship, a joint survey was conducted by officials of various departments in those areas, Lordship. Some various structures have been found, Lordship. We would like to bring the records by way of an affidavit.
You were supposed to file affidavit earlier also.
We just recently got the report, Lordship.
Then consult for the forest department, you are for the forest department.
Forest Department.
Forest department place some time to place on record the joint survey report prepared by the officers of the prepared by the forest officers. Will stop. Will stop in 3 weeks.
Okay.
Item number 4 and 5.
My lord, this is a PL. Basically, my lord, regarding the environmental degradation in the state. Now, what is the basic problem, my lord? The forest department, government of Assam, they do not have the working plan for these reserve forest fund. That's a very unfortunate state of affairs. Because, my lord, a working plan for a divisional forest office is something like, my lord, basic arithmetic, my lord. Unless you, I don't know. আজি যিখন আসাম পিজন নিউজ পেপাৰ আমাৰ গুৱাহাটী ডিষ্ট্ৰিক্ট বাইকতে আমাৰ ঘৰতে আছে ওপৰত লৈ ৰাতি গধূলি আৰু আজি এজন কোনোবা এজন ধুনীয়াকৈ খুব ভাল চাজেশ্যন সেই মানুহটোক মই মাথাই নাই % decline in Guwahati forest cover in 43 years. Global forest bonds.
The response by all the 4 states is there
Yes, madam. Now by and large it is there.
by and large. Now, what do you, now in, I think so in the, we think so in the response they must have,
So my lord, I have gone through the responses. I don't think, my lord, these are enough to take a call in the matter.
how?
For example, my lord, none other than the Honorable Chief Minister of the state had said, my lord, that according to the Chief Minister, my lord, which was quoted by Global Forest Watch, that about 4,350 square kilometer of forest was lost in NE. That's a 52%, my lord, and 3 times the size of Delhi. My lord, State is doing, I am not saying that state is not doing. I think something more is to be done, my lord. There are basic few things. For example, why there are working plans are not there for the districts? They don't know, my lord, we're writing under RTI, they're not even responding. Whenever they're responding very evasively. End of the day, my lord, we are all facing the burn. So therefore, my lord, we are not trying to put blame on anybody. Only thing is, my lord, the environment should improve.
And what about?
Or what I
What about the plans of other states?
my lord, they have filed their affidavit, but my lord, with two states, at least I know state of Nagaland and Arunachal Pradesh, even my lord, proceedings are pending in Supreme Court under Article 131. Because
In respect of
this
these two
border,
states.
yes, my lord. And my lord, these are one of the basic reason with destruction is taking place. So many, my lord, problems peculiar to the Northeast is involved, my lord. So at least, my lord, lordships we can urge upon your lordships to address those minimum basic requirements so that at least, my lord, the growth of the forest is there. So that tomorrow, the next generation do not face any problem. And the stand of the states are, my lord, that there is a because of the pendency of the case before the Honorable Supreme Court. This is a case of 88, 2 of 88.
Acha, Mr. Chaudhary,
Yes.
what we are suggesting is since all the four states have filed their affidavit,
Yes,
why don't you file a consolidated rejoinder
okay.
and also put in your suggestions, if
Certainly.
any, and we'll consider it and.
I think that will be
That'll
better.
be a better way forward.
Lordship, my learned friend is today raising the issue of working plan. There is a suo motu PIL 3/2023, where we are upgrading and giving all the status report regarding the ongoing process regarding the working plans. Lordship, this matter maybe if they are also harping on this,
It can
then
be tagged.
it can be taxed.
Some of the sectors you have prepared
Yes.
that working plan
Yes.
and some
The
of the.
BTC area,
that is
2, 3
undergoing
areas
on.
we are still.
Yes,
It can be tagged, Miller.
And Lordship, the response of Mizoram is very important here because we are facing major encroachment in inner line forest in Barak Valley, Lordship, covering 3 districts, Karimganj, Hailakandi, and Kachar. Because of this, we started a commando battalion inside. About 60-70% work is over. There was a PL here also that there is large scale encroachment in the inner line forest. We cleared that inner line forest area. There was encroachment from Mizoram people. Some immigrants also were there. And we constructed about 60% of the commando, and that commando battalion will be exclusively dealing with those illegal activities, nothing to do with the regular law and order situation. A petition has come up in the National Green Tribunal where I am appearing. And finally, we have to stop the work there. Because according to we have to take certain permissions from central government, which according to us is not required because this is an ancillary work which is permissible under the Act of 1980. So that process is going on, and even that if the permission is also required, that process also we have started. So identical commando battalion is also proposed in the area in one of the forest near bordering Arunachal Pradesh also. So the state government is proactive in this line, Lordship. We have realized, we have done, and that commando battalion stop all illegal activities. Last year, when some of our officials went there to remove some of the extremist organizations in the inner lane forest, Lordship, there was rampant firing on our officials. The SP is still languishing in the hospital, and 6 policemen were killed. So that is happening in inner line forest,
In that border to which state?
bordering Mizoram.
Mizoram.
That is why Mizoram's affidavit is very much essential here.
Yes, yeah,
What they are doing in inner line forest.
Who is from the Mizoram? Yes, ma'am.
They are silent in this very critical aspect.
I have filed one affidavit, Lordship, that is on page 309, Lordship. My stand is this, Lordship, talk is going on between the government of Assam and government of Mizoram, Lordship, regarding the border dispute, Lordship. That is a stand of mine. Since long
We
time,
are
some,
not going into this border dispute.
yes.
Well, regarding this preservation of forest and the working plans about that,
Then
what
in
you
this
propose?
aspect, I have to file another affidavit, Lordship.
Ma'am,
The
the
government of
petition
Mizoram
is only for this
puts there.
purpose, and you are simply saying that border dispute is there. We are not here to solve the border dispute between the two states.
Only that instruction is with me, and that in this respect, affidavit was filed, Lordship.
Your instructions with you, we are not concerned with that.
Regarding this,
You have to file the response to the writ petition. What
In-
instructions, if
in
the
writ
writ
petition,
petition is
Lordship-
raising something other concern and you are having instructions.
these
in some
points are
other
not,
concern,
this submission are not in the writ petition, Lordship, what my learned friend stated
It's
today.
there. The photographs are there.
Only photographs, but
The photograph
in the affidavit that was there.
where there is large scale encroachment in.
Encroachment is
forest.
there.
All in that area only we have removed the encroachment area and we have.
In fact, my lord, during the course of the proceeding, when the then Honorable Chief Justice noticed that all the states are also involved, then only notices were issued.
Yeah,
And he
that's
said,
right.
yes.
It is, on the last occasion only.
Then I will file a details affidavit, Lordship.
Lordship, may you please to give an observation in the today's order that what they are doing to
Yes, yes.
remove the encroachment done by Mizoram government in inner line forest,
Oh.
which is part of Assam. It is correct. On record, I am saying, Lordship, whatever, these are part of the record.
Mr. Tsekya, what is inner line forest according to you, my lord?
It's a reserve for name of that forest,
Inner line forest.
inner line forest. Huge, about 800 square kilometers, something like.
That area is INNER.
Its name came from 1883.
Yeah. না এবার আমি এটা কি করবো দেখবো আমি সাজেশন দিব
Yeah, what about this, Arunachal Pradesh and Nagaland? Your file.
Only to the extent of what they have said in the affidavit. Obviously, we were originally not even involved in.
Yeah, that's right. But have you elaborated this? What measures the Arunachal Pradesh has
We
taken?
have a document, like, when you see affidavit that we filed.
Yeah,
Paragraph 6 and
this-
7. What we are saying is, there are some areas which have been under dispute for substantially long time. There are litigations pending because it's almost free. Those are areas we cannot possibly think of entering into because Assam is claiming it to be their part of their boundary. We are saying that no, it falls in ours. So if we enter into those areas, there are serious law and order situation might.
apart from that, those areas, what about the whole state?
That of course is not. It is pertaining to the PIL itself is targeted against Assam.
But
So there's
here
no-
I think so the scope of the PIL is enlarged.
You'll
By
also
this
show
order
that-
dated 12/10/2023, that's why only the response from all the states have been asked for.
So the response was asked for in the context of the affidavit file where they annexed a report saying that there is encroachment by people from Arunachal, Mizoram and Nagaland. It is only to that extent that response was.
What learned counsel representing the state of Mizoram, Arunachal, Nagaland submit that due to want of complete instruction, affidavit could not be filed in these proceedings. In fact, the court has taken note of this. The perusal of the affidavit is significant areas of forest which are located on the common borders of the state of Nagaland have been encroached upon. In view of the fact that direct VD Goswami landed so and so and so. Copy of the additional effort shall be made, coordination between the secretaries of government to encroachment with respect to boundary disputes. This is what the court has observed, sir.
That is personal.
Effort shall be made in coordination with the secretaries of the concerned Assam, Mizoram, Nagaland, Arunachal Pradesh to resolve the issue of encroachment irrespective of the boundary dispute. So we are not concerned with the boundary dispute. We are simply said, what about the encroachments in the forest areas of the whole of the states?
That is precisely the problem. Moment, there are areas which are overlapping. They say, Assam says that it belongs to them.
That's
Now, the moment we start taking any action, firstly, we'll have to face, there would be a law and order situation that would arise. And secondly, Assam would say that you are encroaching into my area and you do not have jurisdiction over this.
That's why only the court has said, please sit together and resolve this issue.
Unless,
And you can very well make a joint effort for the purpose of removal of encroachment, at least forget about the boundary dispute, you get it decided later on.
to that extent, there are joint committees so far as Arunachal is concerned. Some committees have been formed.
And madam, what about Nagaland? Have you filed your response? Now, what you have said in your affidavit? This is the only response. So you will not take any action against the encroachers. This will mean that since the matter is pending with the Supreme Court, will not touch the issue. Arunachal Pradesh. So, this court by the order dated 26/7/2023 directed the respective councils of the states of Mizoram, Nagaland, and Arunachal Pradesh to preserve lands situated on the borders of the state, on the borders of those state, on the borders of those state with state of Assam. Stop. For that purpose, 6 weeks time is granted to the respective councils.
Exchange biddings.
The copy of the affidavits be supplied to
6 weeks time for what?
for within the can copy of the said affidavits be supplied to Mr. Counsel for the petitioner, Mr. Chaudhary, and the Advocate General of Assam in advance. This up to 8 weeks.
Item 7 and 8.
Regulation গুলো আছে নয় কপি গুলা Lord,
Yeah.
if your lordships would kindly come to page number 98 of writ appeal number 318, There are two writ appeals, my lord. If your lordship would kindly take the paper book of writ appeal number 318.
Yes.
Lord, please come to page number 98.
It is also a position load,
Yes.
Yes.
promotion, which post to which post?
This is, my lord. Actually, I was promoted to the post of environmental scientist. Sorry, from environmental scientist to assistant executive environmental scientist, which has been interfered with by the learned single judge, my lord.
Same ground, no qualification or what?
No, no, no. Here it is other way around. I have qualification, they do not have.
There a stay order?
No. Stay order? No, no stay order.
We'll hear along with that, same matter. 27. It's not.
Item 9 and 10.
Deeply. Maybe lordship. In 10 lordship, I want on time lordship, only for the week lordship. Next week, my senior will be available lordship.
Somebody has objected to it.
Yes, your lordship, my senior is on leg, he is coming.
Madam, he is seeking time to, in item number 10, which is connected matter.
Yes,
they are
it is.
seeking
Mine
some
is
time.
replenishing is
Yes,
here.
your lordship, item number 9, we can start. If my senior,
Those are the connected matters.
yeah. they got it.
Then they start to 2 weeks. We'll hear these matters after 2 weeks.
Lordship.
Item 11.
May I please? My lord, last occasions, my learned friend referred to a judgment of your lordship, my lord. Past in
Learned friend has not referred to you. Short time, I want to go through those.
yes, lordship, my lord, in the judge, I have read the judgment, my lord. That judgment was, my lord, where the impugned was the notification of the ROP, my lord, which was put to challenge. And here we are claiming the benefit on the basis of that notification, my lord. We are not challenging the our amended ROP, my lord. There's a difference. And in fact, Honorable, this court has recorded the submissions which I shall make today, my lord, that have been already recorded and in the judgment, my lord. Here the petitioners are, my lord, the upper primary teachers. They are teaching from class 6 to 8, my lord. And in the earlier case, the teachers were LP school teachers. They were teaching from 1 to 5, my lord.
Upper primary school teachers are also there.
Lordship?
Some upper primary school teachers are also there.
Oh, their issue was there, my lord. They were given the 7,400 grade pay, and they claimed that they ought to have been given the 8,700.
Earlier, they were fixed in the 8,700.
Yes, initially when
they were fixed in
Yes,
7,400. They have challenged that.
Yes, initially when the ROP has come, my lord, all the teachers, primary teachers are given the 8,700. Thereafter, modification has been done through anomaly committee, and then, my lord, it is refixed 7,400 for the teachers who are serving in class 1 to 5, my lord. And here we are serving from class 7 to class
Your
6.
qualification,
The qualification is, my lord, I'm coming to the qualification. Qualification is as per NCT norms, my lord, graduation with DLED or my lord, graduation or higher secondary is also there. Higher secondary now, as per after coming into the force of the NCRT Act 2009, NCT has given the minimum qualification notification. According to that, my lord, graduation come DLED is one of the minimum qualifications for teaching in class 6 to 8, my lord. And Accordingly, the teachers who were underqualified, who are not up to the level of the NCT prescribed qualification, they were given the opportunity to upgrade themselves, my lord. We have acquired the qualification degree as well as the DLED qualification in the meantime, my lord. And during that period, the school of the petitioners have been amalgamated with the high secondary school department, high school department.
For the purpose of appointment in the upper primary school, that is 6 to 8 or whatever standard to teach the 6 to 8 standard, what is the entry qualification?
Yes, qualification is given, my lord. I've annexed
Entry qualification,
graduation.
graduation
Yes.
or this
No,
secondary?
No, page 45, my lord. I've given the NCT notification. Graduation and 2-year diploma in elementary education. By what?
Page?
Page 45, my lord. This is the NCT notification, my lord. After enactment of the RT Act 2009, this notification has been issued, my lord. Page 45, my lord, the two sections, upper 1 to class 5 is there. Thereafter, Roman 2, my lord, 6 to 8. Your lordship, A is given graduation and 2-year diploma in elementary education, graduation with at least 50% marks and 1-year bachelor in education, or graduation at least 45% marks and 1-year bachelor in education BEd in accordance with the NCT regulation norms and procedure regulations issued from time to time in that regard, or say senior secondary, my lord. These graduations are one of the qualifications. And therefore, the petitioners, like other teachers of the entire state, my lord, they were given the opportunity to upgrade themselves to the standard of NCT prescribed qualification. Accordingly, my lord, all the teachers who are serving in the upper primary schools, my lord, are not amalgamated. They have been given, already given, my lord. They are enjoying the scale of 8,700. This is admitted position. And only the three teachers are from Kachar district, my lord, they were not given. They have been, in the meantime, during the process of amalgamation, their schools have been amalgamated and they have been excluded, my lord. Therefore, I have annexed the, my lord, orders, and even they have annexed the pay bills. Pay bills. Page 75, your lordship will find, this is an example of the order. Where after completion of the qualification, they are declared a trained graduate teacher, and they have been given the scale of pay as per graduate 8,700, my lord. From 6,800 to 8,700, they have been given. Page number 75, I have given one example. Thereafter, my lord, I've annexed also the one. I've collected some bills where it clearly says the assistant Hindi teacher and assistant teachers of upper primary schools, they are enjoying the great pay of rupees 8,700. In the state, entire state, all the teachers are enjoying well. This is admitted position. And they are enjoying on the basis of the amended ROP. During the
What are you arguing, Mr.?
lordship,
When you were appointed in the service in the year 1998, 2014 and 2022, you were not having that qualification?
not having the
And later on, during the course of
Yes.
service, you acquired those qualifications?
yes,
And on the basis of that, now you are claiming that you should be paid as a graduate
on the
teacher?
basis of that, my lord, on the basis of that, my lord, the entire in the teachers like petitioners in the entire state of Assam are getting,
Your at
and
that
the
time
orders,
of appointment.
orders are
At
given.
that time, your appointment in this service, what was your qualification?
That was, my lord, graduation, so higher secondary, my lord.
That's all. Matter ends there. How can you claim? And you're trying to get this judgment is supporting you.
My lord,
Shows which part of the judgment says that any person who acquired subsequent qualification of graduation subsequently is entitled to that pay. Shows in the judgment.
my lord, in the judgment, my lord, your lordship has quoted the
Just give the copy of the judge. Do you have other copies?
only one paper. Yellow permanent. আগত বেশি। না, এটা হল দিতে পারছেন বাকিটা আমি ওটা দিতে হবে।
Subsequently, graduation and
Yes.
My lord, I take your lordship to page number 188 of my additional affidavit, my lord.
Yes.
My lord, in this anomaly committee report, my lord, it is anomaly committee has clearly stated, my lord, the commission feels that at the level of LP and ME schools, there are no justification for differentiating the qualification of science graduate vis-a-vis arts graduate or any other graduate. Accordingly, the commission recommends that the entire graduate entire graduate teacher in LP and ME school should have the same GP of rupees 3,300. It is further recommended that all other teachers who have undergraduate qualification should be put in grade P GP of rupees 2,500. In the above recommendations, the seventh Assam Pay Commission mentioned that there is no justification for determining the qualification of science graduate vis-a-vis arts graduate or any other graduate teacher in case of LP and ME schools. So the commission recommended pay scale of other trained graduate teachers at par with the science graduate teachers without discrimination. But the fact is that in case of LP junior basic schools, there are no science, arts, or any other graduate post. This category of post exists only in ME school. The committee examined the minimum entry qualification required for the various categories of post of teachers as per existing applicable service rule. The minimum qualification of teachers of LP school is undergraduate. Therefore, the scale of pay of graduate teachers prescribed is not justified in case of teachers of LP schools. Anomaly committee carefully scrutinized the recommendations made by the previous pay commission, and it has been found that ROP rules 1990 and 1988, there was no categories of pay scale of LP school teachers, that is trained teachers and untrained teachers. But the ROP 2010, the LP school teachers have been classified under three categories: trained graduate teachers, trained undergraduate teachers, and untrained teachers. The pay scale of these teachers were recommended in the same pay band with different grade pay, that is grade pay of rupees 2,700 for trained graduate teachers and 2,500 for other two categories of teachers. Therefore, the anomaly committee, in view of that, there should be different grade pay for different categories of LP school teachers in accordance with the ROP rule of 2010. After careful consideration, the committee recommends grade pay of rupees 7,400 for trained graduate teachers and 6,800 for untrained graduate teachers, including trained undergraduate teachers, and 6,200 for untrained teachers under ROP rules. As per information available at present, the senior-most teacher in LP school is allowed to hold charge as in-charge headmaster. There is no specific post of headmaster for LP school. The pay scale of headmaster of LP school has to be decided by the government in administrative department while creating post if considered necessary. Therefore, it will be inappropriate for the anomaly committee for prescribing any pay scale for the headmaster of LP school. In case of ME and other upper primary schools, the anomaly committee feels that there should be parity of pay scale amongst all teachers, irrespective of streams, arts, science, commerce, etc. Therefore, the anomaly committee recommends grade pay of rupees 8,700 to trained graduate teachers as applicable to the science graduate teachers. The committee also recommends grade pay of rupees 6,800 to the untrained graduate teachers, including trained undergraduate teachers and untrained undergraduate teachers. The remaining teachers without training shall continue to get grade pay of rupees 6,200. So, my lord, this has come into force with effect from 1/4/2016, my lord. The committee has decided to give a grade pay of rupees 8,700 to the trained graduate teachers. And we are for acquiring the qualification as per NCT norms, my lord. We are trained graduate teachers. And this is not the end, my lord. The department has also, my lord, decided in the says, my lord, I'm taking ownership to the minutes of the page number 195.
Yes.
That is the minutes, my lord, where the department, my lord, relevant portion at page number 197.
Yes, yes.
Examining all aspects and after a detailed discussion, it was decided in the meeting that the teachers whose schools were amalgamated with the higher secondary or high school prior to the scheme Shiksha Kshetra and are still drawing undergraduate scale of pay, in spite of the fact that they are graduate prior to amalgamation of their schools, may be allowed to draw graduate scale of pay at such and such graduate teacher of high schools in accordance with the provisions of Assam Services Pay Revision of Pay Rules 2017, and notification is issued, my lord. And on the basis of that, my lord, similarly situated ME school teachers who are having the graduations, my lord, amalgamated with the high schools, my lord, they have been given the grade pay of rupees 8,700.
That similarly situated teacher.
Yes, my lord.
Where is his particulars?
Yes, page 75 of the page 75 is the order I have given, my lord. This in respect of only 3 teachers I have given. Page 75. They are the teachers of upper primary schools, my lord. They have been given the teachers who are serving in the LP school having graduation, they are getting salary more than us. The teachers, my lord, one thing, my lord, teachers having graduation degree serving in the LP school, my lord, they are getting 7,400 grade pay. And we are, in spite of having graduation, we are getting 6,800 in the high school. But there is in LP school, my lord, minimum qualification is at that time matriculation, now it is higher secondary. But they have been given the graduate pay, scale of pay of rupees 7,400. They are enjoying more than us. In spite of having the qualification, my lord, we are not getting, because this is with effect from 1/4/2016, it is given. And you will find at page number 75, the teachers of the upper primary schools after completion of the, my lord, qualification as per prescription of the NCT, my lord, they are also given.
Yes, Mr. Majumdar.
Petitioners were all appointed prior to 2012. Matlab, if you go by the rules, prior to 2012, the minimum qualification required for being appointed to upper primary school was higher secondary. They all came in with the higher secondary qualification. Thereby, they are being classified as junior teachers, even if they are serving in the secondary school. The Secondary Education Act clarifies that. Wherever the minimum qualification was of a higher secondary, who came in with a higher secondary is a junior teacher, not a graduate teacher. The only claim which they try to make today is that we have acquired our graduation, so consider us graduate teachers. But that has been negated by this honorable. It cannot be, they cannot be considered to be.
Okay, this petition is, this writ appeal is filed by the petitioners being agreed with the order dated 29/3/2022, passed by the learned single judge in writ petition number 251/2021. Whereby the learned single judge has dismissed the writ petition filed by the appellants and has refused to grant relief to them to fix the petitioners in the pay scale in the grade pay of rupees 8,700 instead of 6,800. Full stop. The learned single judge has observed that at the time of entry of the petitioners in the government job, that is entry of the appellants in the government, at the time of entry of the appellants in the government job, that is in the year 1998, 2014 and 2002 respectively, they were not holding the degree of graduation, and the said degree was obtained by them while in service. Full stop. The learned single judge has also taken into consideration the fact that the entry qualification on the post of teacher, comma, when the petitioners, when the appellants were initially appointed, was higher secondary and not the graduation. The learned single judge, after going through the provisions of the ROP 2017, has held that there is no illegality in the action of the respondents in fixing the petitioners in the grade pay of rupees 6,800. Stop. Having heard the learned concept of the appellant, and after taking into consideration the fact that at the time when the appellants were appointed as teachers in the Which school? This is ME school,
Upper primary.
upper primary school. They were not. The entry qualification for the said post was undergraduate, and admittedly, the petitioners, the appellants were undergraduate. Full stop. Undergraduate. And in such circumstances, even though if they have obtained the graduation degree later on during in service, they are not entitled for a grade pay which is applicable in the case of graduate teachers. Hence, we don't find any merit in this. The same is therefore.
Item 12.
May I please, your lord? My lord, this matter relates to, my lord, the state of Assam has conducted a TET examination, my lord, for the purpose of manning in the Madrasa institutions of the state, my lord. My lordship is well aware, my lord, that the state of Assam has transformed all these Madrasa institutions by way of an act, my lord, into, my lord, general schools. So now at this moment, my lord, there are no existence of these Madrasa institutions, my lord. These are all being transformed into, my lord, general schools, my lord, as the from upper primary to, my lord, secondary level schools.
Since when?
My lord, it has been done in the year 2020, my lord.
2020.
2020, my lord. But
Okay.
the issues are, my lord, prior to that, my lord.
Okay.
My lord, what has happened?
So what remains now in this petition?
My lord, it remains because, my lord, our claim is that, my lord, the category of TET which has been conducted, my lord, and in which category we have passed out. My lord, can this category can be accommodated also in the general schools, my lord? And the state of Assam has already done also, my lord, that the sum of the persons, my lord, has already got appointment on the strength of this Madrasa TET qualification to the general schools also, my lord. Now, my lord, what has happened? On the one hand, they have allowed, my lord, the sum of the TET qualified candidates to, my lord, allow participation in the recruitment process of the general schools, my lord. But suddenly that policy has been stopped by way of a notification initially in the year 2019, my lord, 5/1/2019, that henceforth, my lord, that we are not allowing the Madrasa TET qualification to, my lord, get the benefit of Madrasa TET in general schools. Now, my lord, though that notification had been challenged in a, my lord, series of writ petitions, my lord, and the learned single judge has upheld the decision of the government on the categorical and detailed judgment has been passed, my lord, and that judgment is under challenge here, my lord.
By the appellants.
Yes, my lord, these appellants were the, my lord, parties in the original writ petition. Some of them has come up, my lord, but not all, my lord.
Not all.
My lord.
Let us see, we'll go through this since the
My lord.
judgment is there.
My lord.
The next date we'll go through it.
My lord.
Then we'll.
It needs some, my lord, another issue, my lord, I beg to draw to my lordship's attention, my lord. The decision of the government regarding the, my lord, cancellation of these Madrasa institutions has been put into challenge before this honorable court, my lord. And this honorable court has also upheld the decision of the government, my lord. And that has now pending before the honorable apex court also. My lord, that is a different issue, not connected with the same.
Different.
My lord. My lord.
Let's see.
My lord. My lord, a short date, may I pray, my lord, some urgency is there because new recruitment is coming up, my lord.
2022 appeal is there.
My lord. My lord.
2 weeks.
My lord.
Item 13 and 14.
Obliged.
Sekya, we have not gone through these files due to some preoccupation.
Lordship.
We have not gone through the case file.
Lordship,
the last night. So on any other day,
Lordship. Some short date if possible, my lord. Some short date if possible.
you suggest like.
I think even the. Can it be on, my lord? 16 or 14 minutes as per your lordship's convenience.
I have no
And my
problem.
senior
16.
60. But can it be on 28th, my lord? 20th. I'm sorry, my lord. I'm sorry. I'm sorry. My colleague has some.